11. A home for the family. The old saying, "A man's home is his castle," is full of meaning and emotional tone because of the memories and experiences that make up family life and the friendships which center about the home. Whether an individual owns his home or lives in one which is owned by another, there is a feeling of possession about it. Because millions do live in homes which are owned by others, the subject of landlord and tenant, including their rights and duties toward each other, is very important to the family. A contractual relationship. This relationship is usually entered into by contract, which is either express or implied. By means of the contract, the person owning the property, called the landlord or lessor, grants to the tenant or lessee the right to use certain property. This may be a house, an apartment, one room, an office, or some interest in land which does not particularly affect the family life, such as a mining or oil well lease. As this is a contractual relationship, it is necessary to conform to the essentials of a legal contract. There must be an agreement by competent parties, property, which is the object of the agreement, and sufficient consideration, which in this type of contract is the rent. There must be delivery and acceptance. Usually the contract must be in writing and sometimes under seal. Questions which may arise under this relationship. Both the landlord and the tenant need to know about their rights and responsibilities for repairs, the payment of rent, and the assignment or sublease of the property. Among the questions that most often arise are the following. What is the best form of lease? And how long will the lease run if the date is not expressly stipulated? What will happen if the tenant moves out before the expiration of the lease or the property is destroyed? What will constitute an eviction? And how will the lease be terminated? Who is responsible for injuries to the tenant or to a third party if the premises are defective? Who is entitled to improvements made on the property? Both landlord and tenant should be informed on these points. The lease. A lease is a conveyance of a particular estate and lands, and it conveys less than the entire interest of the lessor. It takes effect only from the time of its delivery and not from the time it is dated, unless otherwise stated, and there can be no delivery without an express or implied acceptance. Delivery implies a manual transfer of possession from one person to another, but entering into possession is sufficient delivery. In a recent case, the owner of a piece of land leased it to a tenant who agreed to pay the taxes instead of the rent as consideration. He did not do this, so after a few years the property was sold to the county for taxes and a tax deed was issued. The tenant then purchased the land from the county and took the title without notice to the former owner. The tenant was guilty of bad faith, for he had written a letter to the landlord in which he recognized him as the owner of the land. When his offer to pay the taxes for the use of the land was accepted and he went into possession, a landlord-tenant relationship was established. The lease may be either for a fixed term, such as for years, for a week, or for a month, or at the will of the parties, and in the latter case it can be terminated when either party wishes. A lease to a person during minority is a good lease, for the time of attaining majority is definitely fixed by law. A lease may contain an option which gives the lessor or lessee the privilege of continuing the tenancy for a longer period, but the tenancy terminates with the expiration of the term as first agreed unless the option is exercised. It is said that an oral, or parole lease as it is called, is a very one-sided agreement, for it usually benefits the landlord. At common law, the tenant was likely to be in an extremely unfair situation and have to pay rent on property after it had been destroyed, or do something else equally inequitable. The subject of leases is now largely controlled by the statutes of the individual states. At common law, it was not necessary to have a lease in writing regardless of the length of time that it was to run. But in 1677, the very important law previously mentioned, called the Statute of Frauds, was enacted. It was declared that every lease for more than 3 years should be in writing and signed by the parties, or it would have the effect of a lease at will only. As this statute had not been enacted at the time this country was settled, it did not form a part of the common law which was taken over at that time. But there are now statutes in practically all states based on the Statute of Frauds. Many states require all leases for more than 1 year to be in writing, though usually it is not necessary to have a seal. What will constitute sufficient writing has been a fine point of interpretation at times. However, A letter showing a specific offer and one of acceptance is sufficient to constitute a valid lease. But if new terms are proposed in the letter of acceptance, no lease exists until the new terms are accepted by the other party. In a very early Massachusetts case, a signed and dated receipt on a bill of sale of hay and oats with the memorandum, left at stable on O Street where P takes possession. Rent to begin October 1st, 1870, for 1 year at $150, was held to be a lease, and oral evidence was admitted to show that the premises consisted of a lot of land on which there was a stable too. A lease is construed according to the will of the parties, but an agreement entered into verbally will not hold against the agreement in the lease, though the written portions of a lease hold over the printed ones. The lease must contain a description of the property, and also the restrictions and covenants stating the terms which are binding on the parties. A refusal of either party to take or give the lease is a breach of contract, and suit may be brought for damages. But first there must be a demand upon the party who is either to give or accept the lease. If a man leases property which he afterwards sells, two situations may arise, depending upon whether there is an oral lease at the will of the parties or a lease in writing. In the first case, the tenant is at the mercy of the new owner and has no rights which he can enforce. If there is a written lease, the new owner has the right of possession of the property, but takes it subject to the lease. Either party may have a right of action if they cannot settle their controversy satisfactorily. The owner might have to evict the tenant if he wished the property, and the tenant, on the other hand, could sue for damage on account of the loss and inconvenience which it caused him. A great deal depends upon the custom and statutes in the different states. There is a distinction between a lease and an agreement for a lease. The difference is important, for if it is a present lease, it cannot be varied by other evidence, and the parties are bound by it. But if it is an agreement for a future lease, it is incomplete and may be changed. The intent of the parties, which is shown by the terms of the agreement, is the test. For example, when a wrote B that he would take a house at a specific rent for 2 years if the house was painted, and B replied that he would accept this offer and immediately painted the house. This was a lease, not an offer of one, for there was nothing left to be completed. In the main, the same parties who are competent to make a valid contract can also make a lease. A lease made by a person non-composed mentis is void unless it has been executed. One made by a minor is not void but may be avoided. A guardian may lease his minor ward's land during minority, though a single member of a partnership cannot make a valid lease of partnership land. Usual covenants. There is no limit to the number of covenants or agreements which may be inserted in a lease, for the parties can impose liabilities and raise limitations as they wish. The usual ones that are implied, if not expressed, arise by law through the use of certain words, as grant, demise, or lease, and depend upon the practice in the particular community. The most common covenants are that the lessee shall pay rent, keep the premises in repair, and shall have exclusive possession, or right to quiet enjoyment of the property by reason of his interest in it. The landlord shall pay the taxes and have a right to inspect the premises to see that they are kept in good condition. The less usual covenants are that the tenant shall build in case of accidental destruction, shall neither assign, sublease, nor conduct a particular business. Sometimes the rent ceases in case the property is destroyed, and sometimes the landlord has the right of entry if the rent is not paid or if the tenant breaks other agreements. More about covenants. Certain covenants are said to run with the land and to bind not only the tenant who enters under the lease, but anyone who may receive the lease from him through assignment or sublease. In an assignment, the tenant transfers the whole or part of his interest for the whole period of time, while in a sublease he transfers the whole or part of his interest for a portion of the period only. This creates a new relation of landlord and tenant. It has been held that if an instrument disposes of a whole unexpired term but contains a covenant to surrender the premises on the last day of the term, it is a sublease and not an assignment. A tenant can assign when there is a condition in the lease against subleasing, and, likewise, if there is a condition which prohibits assigning, he can sublease without violating the condition. In a few states, there are statutes forbidding the transfer of property to another without the consent of the landlord. But in the absence of such a provision in the lease, the tenant may assign, sublease, or mortgage the property. A sublease does not affect the liability between the lessor and the lessee, except that the lessee's rights of possession have been transferred to the subtenant. There is no contract between the lessor and the subtenant, and so he is not liable to the original landlord but holds of the lessee, who has become his landlord. The subtenant, however, takes the property subject to all the restrictions under which the tenant held it, and if he commits any act which is forbidden, this will constitute a breach of condition for which the landlord can enter and terminate the lease. The decisions concerning the responsibility of a sublessee or assignee to build or to make repairs are somewhat in conflict. An Old English case held that an agreement to build a wall on a certain part of the property did not bind the sublessee to do this unless the wall was in existence at the time of leasing. An agreement relating to something to be built afterward was not binding. This rule has been followed in many decisions since, but other courts have held that there is no difference between a covenant to improve land by building on it and a covenant to improve the same land by repairing the building already on it. No implied warranty of fitness. Usually there is no implied warranty that a house which is leased is fit for habitation or that the premises are fit for the purposes for which they are hired. The lessee has an opportunity to inspect the premises, and so no duty rests upon the landlord to see that the premises are fit for the use intended by the lessee. Some courts hold contrary to this, and if a landlord definitely states that the premises are in good condition when they are not, and prevents the tenant from discovering the defects, he acts fraudulently, and the tenant can abandon the lease or sue for damages. However, mere omission to disclose a defect is not fraud. Several states have statutes providing that the lessor of any buildings designed for the residence of human beings must put them in condition fit for occupancy and repair all subsequent dilapidation not due to the tenant's negligence. If this is not done within a reasonable time, the tenant may repair and deduct from the rent or vacate and be discharged from the rent entirely. As a general rule, the landlord is not responsible for repairs which the tenant makes, as it is a presumption that they are made for the tenant's benefit. If the repairs are fixtures, that is, improvements which are chattels that are annexed to the property so that they become a part of it as mantles, heaters, and certain plumbing fixtures have sometimes been held to be a difficult and complicated question may arise. Some courts hold that they may be removed if this can be done without injury to the property, while others hold that as they are a part of the realty they cannot be removed without the consent of the owner. Duty toward each other. During the term of tenancy, it is the general rule in the absence of statute, or a contract to repair or warranty of condition, that the landlord and tenant must use reasonable diligence and care in knowing conditions and in exposing others to danger. Therefore, as a usual thing, unless the landlord expressly agrees to make repairs, he is not liable for them or for injuries to third parties because of failure to make them. But this rule is limited and depends upon who has control of the premises. That is, whether the tenant is in sole possession or the landlord retains possession and control. As sometimes happens in the case of halls and stairways, the landlord has then been held responsible, as he is bound to see that stairways and passageways are reasonable. 6. A recent case involved a similar situation. A suit was brought by lessee to recover damages sustained as a result of the unlawful invasion of leased premises. The facts were that she had occupied the premises for 6 years under a verbal lease, and when the defendant agreed in writing with the owner to buy the property and employed a contractor to make repairs, she was informed that it would be necessary for her to move while the work was being done. She stayed on as she did not wish to move, and led the defendant to believe that she would be willing to submit to the inconvenience of having the remodeling done while in possession of the property. She afterwards claimed that, entirely without her consent, workmen entered and disconnected a water heater. This was in the state of Louisiana, and according to the code of that state, if workmen who were employed by the landlord entered without a tenant's consent, the landlord was liable for all damages. But if the tenant expressly or tacitly consented and permitted workmen to make alterations during the existence of the lease, the landlord was not responsible for damage suffered as a consequence. By asking permission to remain, she consented and could not recover. 6. Payment of rent. There are several important conditions relating to the payment of rent which need to be understood by those entering into a landlord-tenant agreement. At common law, under the feudal system, rent was payable in various kinds of services or crops. Money was not necessarily an incident, as it usually is today. The delivery of the lease is the consideration for the rent, and it is no defense to an action for rent by the landlord that the tenant did not take possession unless the failure was due to the landlord's omission to put the premises in condition as agreed. A landlord is entitled to rent past due, but after the property is sold he cannot claim the proportionate part due him up to the time of sale unless this is provided by statute. Many states now provide for this. The rent is due at the end of the term, whether for a year, quarter, month, or other period. Unless otherwise stated, the tenant has the whole of the last day on which to make payment, and if he is ejected before that time, he may defend an action to collect rent. If the landlord enters except to demand rent, inspect the property, or make repairs as the lease permits, the tenant may abandon the lease and is released from all liability for further rent. If the landlord does anything which can be construed as an eviction, liability for future rent ceases. Eviction, which is one way of terminating the lease, is either actual, which occurs when the landlord forcibly ousts the tenant from possession, or constructive, which occurs when the landlord does something which lessens the value of the property to the tenant or renders the enjoyment of the premises impossible. For instance, if he allows a nuisance to be carried on in an adjacent part of the property, or if he leases the premises for a certain purpose and they prove to be unsuitable for the purpose. When a landlord entered on his property and partially destroyed a summer home, he evicted the tenant. Likewise, when a landlord let some strenuous animals onto grounds which were rented for exhibition purposes, and the animals dug it up and rendered it unfit for use, this was an eviction. Whether a particular act will amount to an eviction or not is a question of fact, and is proved as any other question of fact which is disputed in court. The courts will enforce a lease if possible, but will nevertheless protect the interests of the tenant, particularly against the sudden ending of the lease. It has therefore become the practice to require a notice to quit before the tenant can be actually expelled. This is usually regulated by statute, and unless a definite time is fixed, the time of notice must equal the interval of time between the rent periods, as quarter, month, or week. Death, of course, terminates the lease. Action for distress. The landlord at common law could bring an action to recover the rent, called an action for distress, if rent was in arrears beyond the time allowed by law for payment. By means of this action, he could seize the tenant's goods, and, as the levy was on the leased premises, he could levy on goods belonging to third parties also. In many states, distress is no longer possible, but a process for recovering rent is substituted. In states which do permit the action for distress, the landlord can levy on the goods of the tenant only. In several states, there is a provision for an attachment in favor of the landlord for the recovery of rent, which is different from an attachment which any creditor can bring. It is limited to property which is subject to the landlord's lien, and is controlled by statutes and by the terms of the lease. Before signing a lease, a prospective tenant should read it very carefully, and if he does not thoroughly understand all the conditions, he should consult someone who is familiar with the statutes. The government plans for housing. Closely allied with the subject of landlord and tenant is the program carried on by the federal government, which aims to bring about better housing for tenants and homeowners. Through the Home Owners Loan Corporation, a person who buys property can receive a loan from the federal government up to 90% of the valuation of the property. He can then pay the loan by monthly installments, which are applied on the interest and principal of the loan and the taxes on the property. Therefore, on property worth $10,000, a buyer can make an initial payment of $1, and get a loan of $9,000. By this plan, the borrower knows exactly the amount which he must pay monthly and the date when the entire loan will be paid, for it is all carefully worked out. Many who usually pay rent have become homeowners. Aside from the down payment, it is like renting a home, except that at the end of 17 or 20 years, the individual will own his home, and during that time will have paid 5.5% interest. The government holds the mortgage, and the federal bank that is carrying the loan pays the taxes. According to some officials in this service, there is difficulty if the buyer loses his job or for any other reason is unable to pay. In the District of Columbia, it is possible to foreclose in 3 weeks. But in other states, a buyer has been able to escape eviction for a year and make no payments during that time. Sometimes it even takes 2 years to evict an owner. Therefore, the banks which approach this proposition from a business standpoint have not shown much interest in the 90% loan, as they have to make the foreclosure and turn the property over to the Federal Housing Association with the buyer already evicted. In the past, the laws of many states have aided the small farmers and honest men who have been trying to buy their homes by discouraging foreclosure. So these laws which are now in operation are inadequate in the present situation.